the doctor or dentist, the medical doctor or dentist as a witness when you go to court? How do you behave in the witness box? What are some of the things you say that may put you in trouble? How do you carry yourself about in court? What evidence are you there to adduce? What are some of the slippery slopes that you shouldn't take? And that will be taken by an appeals court judge, Justice Sir Dennis Dominic J, who is a justice of the Court of Appeal of Ghana and then also justice of the African Court. We also have a presentation by the Registrar of the Medical and Dental Council, and that would have to do with discipline among doctors and dentists, the role of the Ghana Medical and Dental Council. Indeed, this will look at issues of discipline. What are the disciplinary processes you will be taken through when you go to when you are reported, for example, to the Medical and Dental Council? And then also, what remedies do you have when you go there? Are you able to go with a lawyer? If you go with a lawyer, what does that mean? What are some of the common cases that are being reported to the Medical and Dental Council that we need to take note of and probably shield ourselves from getting into trouble for? If the Medical and Dental Council finds you guilty of some issue regarding discipline, what processes are you taking through? If you have a challenge to that decision, where are you able to go? And so the third one addresses these issues about medical documentation, and that considers medical reports, the ones we issue for the police, the ones we issue for insurance. What we think is very simple, like excuse duty. Should you just write 6 months excuse duty for any patient without any breaks in between? 2 days is enough to sometimes put somebody in trouble if you don't go through the right processes. And so this is the 3-part series that the committee has put together for us to look at the practical issues and the pertinent issues that have been worrying us and putting some of us in trouble with the Medical and Dental Council in recent times. However, owing to some arrangements and logistical constraints, we would have only one presentation today. We would have the presentation by Dr. Med Raymond Owusu-Ansah, Esquire, on medical documentation by doctors and dentists, with specific mention for medical reports, insurance, and excuse duty reports, and a few others that he may add. So before he begins, just a brief about who our facilitator is. Dr. Med Raymond Papimfus Owusu-Ansah is both a private medical practitioner and a health educator, as well as a legal practitioner with many years of experience across both professions. He has worked both in Kolebu Teaching Hospital as a house officer, proceeding then to Tema General Hospital, where he served until he moved into private practice, and then also underwent his pupillage for the law practice with Bensiencho, Lecha, and Ankuma, and later then joined them as a lawyer until 2020, where he left them. He holds an MBA in finance and then also professional certificates in law, as well as a basic medical certificates as well. He also serves our association as the divisional secretary for the Greater Accra Division. Shall we welcome Dr. Med Raymond Papimfus Owusu-Ansah to take us through today's presentation. Over to you, Dr. May.
Thank you very much, Dr. Salome, my General Secretary. Please, can everybody hear me?
Yes, we can hear you clearly.
Right. So thank you all very much once again for this opportunity to have another conversation with the medical fraternity in our country. This topic is quite pertinent, particularly for such a time like this, especially because if you paid attention to the airwaves, you might have heard that there have been some instances where the medical documentation and reports of practitioners have been subjected to a lot of scrutiny, particularly in the media, in the airwaves, because certain situations raised question marks about why certain documentations probably were produced, not only in the form that they were produced, but at a time when they were produced. So this afternoon, we will be looking at medical documentation, paying particular attention to about 3 key areas where we look at medical reports, and then general insurance reports, as well as exclusivity report, or what in other jurisdictions they'll call a doctor's note. All these essentially have fundamental things in common, which is the documentation, medical documentation by medical practitioners. So my name is Raymond Owusu-Ansah. I said I'm a medical practitioner as well as a medical a lawyer. So my slide is really not moving. I don't know why. Hello, Dr. Tama, you can hear me?
Yes, I can hear you clearly. Yes, yeah. Please.
I'm trying to move my slides, but it looks like they're not moving. So hold on a second.
So maybe you can stop sharing and then share again, and let's see if that solves the problem.
All right.
Okay. In the meantime, members online, you are encouraged to share your questions, not in the chat section, but in the Q&A session. And we'll note the questions and ask them at the appropriate time when the presentation is done. Some of the questions may also be answered directly in the chat section, sorry, in the Q&A session when you put them there. But we will ensure that as many as possible will be answered, if not all of them. Thank you very much.
Okay, I think it's back on now. Right.
All right, thank you.
So I just look at this cartoon just to, as a teaser to what we're going to talk about this afternoon, where you have 2 colleagues in a department, one asking the other, where will we be without the right documentation? And the other person's response is unemployed. Essentially, it addresses the point that as practitioners in our field of practice, if we don't pay particular attention to what we do as far as documentation of our encounter with clients is concerned, the downside of it is that eventually all of us probably will become unemployed. By way of disclaimer, the views and opinions expressed in this presentation are mine and mine only. I do not represent the views of any persons that I am associated with. And in the course of the presentation, certain entities will be mentioned as way of example, and I have no affiliation to any of the named commercial entities or government entities named in this presentation. Any reference to any of such entities is essentially for just emphasis and for the purpose of this presentation. Basically, we'll follow this outline for this afternoon. We'll just look briefly at medical documentation. That's a brief overview. We'll look at medical reports. We'll have a quick look at insurance reports, including matters that border on insurance that are covered by legislation in Ghana. Then we'll take a quick view at exclusivity reports, or what you call a doctor's note. So what is medical documentation? Or essentially, what is documentation? I mean, we are a lot of educated people. When you say you are documenting something, we know what it essentially means. It's just a process of putting down, as someone would say in black and white, I mean, something that you have done. Okay, so when it comes to our practice as physicians, as dentists, medical documentation essentially involves collecting, sometimes coding, ordering, storing, and retrieving certain information that come to us by way of our professional interaction with our client. And we do that with a mind to the future, because those documentations are done not only for the present, but for future situations, as we may get to know as the presentation goes on. And there are a lot of reasons why you will need to document, aside the fact that we will come back to it in the future. It can be to help with the patient care, because obviously when you see clients and then you see them today, you want to see whether they're in progress tomorrow, whatever interventions that you have given are working. So you document our charts, our temperature charts, all those things are documentation that helps us in giving good patient care by looking at progress. And of course, for future reference, as has been said earlier on. And it also provides evidence that care has taken place. So as we will get to know as we go down, you realize that in certain environment, you may need to show evidence that indeed you did the things that you are saying or claim to have done, and need to show evidence that those things were done. And sometimes in certain situations, it may be evidence of showing compliance. So for example, when it comes to certain renewal of even facility licenses, there may be some requirements that you need to fulfill. There may be some reviews of certain procedures or practices that are being done in the facility to more or less ascertain continuous license or relicensing for the practice to go on. It can also be a basis for a proper referral system, which in a sense dovetail into proper patient care. And of course, a good documentation in our field of practice also reduces or decreases the risk of the legal risk associated with our practice. So like I said, it's a quick overview. So we'll just pick some salient points and talk about documentation before we dovetail into the main areas that we're talking about this afternoon. So when it comes to your documentation as a practitioner, there are certain things you need to pay attention to. One, you are not supposed to use whitener, or what in our parlance we call Tipex, all right? Because as I said earlier on, you could realize that this can become a legal document in the future, and you don't want to obliterate or cover any evidence, which may raise suspicion that you are trying to cover up things. And then you never scratch out. Scratching out essentially means using a pen, all right, to literally continuously run through whatever you are trying to cancel so that it doesn't become obvious. Essentially what you need to do when it comes to taking care of your mistake in terms of your documentation is just to draw one line through it, either initial or signed against it. Like, if you had an experience in a banking hall, typically what happens is that if you make a mistake, let's say on a banking form, what you do is that you cross it one and then you sign against it. It's the same thing. There's a reason behind that, so that if there is any audit in the future, which can happen in the court, quote unquote, whatever the mistake was can be seen, everybody can see it, so that it doesn't raise any issue of you trying to hide any information. And then of course you initiate an initial or you sign against it. Other aspects too that you may have to pay attention to as a practitioner, you do not erase, as I mentioned earlier on. You don't scribble out answers, errors. And do not write retaliatory or critical comments. In our line of practice, sometimes you may have very difficult clients that you may be dealing with. And in your interaction with them, when you sometimes probably may get angry or a bit ruffled, instead of being objective, you end up being quite subjective, and your writing, if somebody picks your writing and see the tone, just by reading it, can see the kind of tone that you're writing. You don't write retaliatory kind of comments. You must be as objective as possible in your documentation. And then the issue of blame gaming, all right? It is fascinating to know that you can find yourself in a place where you may have colleagues who work within the same environment, sometimes even the same department, all right? And when it comes to the way things are documented, it looks as if there is some kind of blame shifting. You don't do that, because at the end of the day, when that document is picked as a whole within certain environment, all right, all of you will go down with it. So you must, again, remain as objective as possible when it comes to your documentation, irrespective of whatever differences that you have at your place of work. And then you must try to correct errors as promptly as you can, because you don't want certain things to crystallize before you want to go back, because that will more or less indicate that you're trying to alter, the history or the story that has already been told. And sometimes that a criminal motive can even be impugned when it comes to situations like that. And then your spellings are also very, very important. Very, very important. You don't want to write one thing when you actually mean the other. And like I said earlier on, you must be objective in your documentation as much as possible. So this is just a cartoon to show, like in the days of old, I'm sure we all have seen pictures of caves where you have writings and carvings that tell a story. So essentially what this picture portrays is that in the days of the hunter-gathering times, this is a father telling the daughter that if you don't pictograph it, it didn't happen. Essentially what it means is that they went hunting, they killed an animal, but who will know that that has happened? The father has to find a way of doing it in the cave to show that this story actually took place somewhere here. The same thing applies when it comes to certain environments in the work that we do. Essentially, if what you have done or you claim to have done is not documented, essentially it can be taken as it never happened. And you can imagine what that can do when it comes to, let's say, insurance claims, the effect it can have on your client and all that. So documentation is very, very important. And now in the days of social media and other portals that we use, courts in various jurisdictions have held agreements that have been done on such of these medias as being valid. And so in your interaction with client, you must also do well that you document every interaction that also happen. I have been part of a medico-legal case in court in Accra where, as part of the evidence that we presented, or the teams on both sides presented, included printout of WhatsApp messages. So bear in mind, don't take it that, this is outside the hospital, so it doesn't count. It really does count. If there are any communications that have happened between you and your client, that is also very important. You must get all that documented as far as possible and as early as possible. Now, also, with the shift from paper system to mostly electronic system, which is happening almost in all facilities now, there are certain key things when it comes to what we call information security and data protection. Essentially, every information or data that is captured must have certain attributes. We call it CIA. Then in our environment, that data must exhibit some level of confidentiality. Okay, so if you're taking data from your client, okay, that data must be kept as confidential as possible. So comes in the issue of tiering. So in a facility, in a hospital setting, how many people, based on different work, the cadres of healthcare professionals, have access to the same information about the client? Must, let's say, the person at records be able to see the presenting complaint, diagnosis, and everything of the client just because he works in a hospital? What protective mechanisms have we put in place so that the person at the records does not see a condition of a patient and ends up maybe blowing it in an environment where he's not supposed to talk about it and create problem for the facility? So there has to be some level of checking who have access to what. That is very, very important. Then that information, data that you are collecting about the client, must also be as whole as possible. The data must have integrity. If the data goes in today, if you need it tomorrow, if a court is asking you to submit or present the medical records of this patient, are you able to get that records out of that system? And this is very, very important because this is a personal experience. So I have a colleague who owns a private facility, and then there was an issue. There's a client who passed away, has a very bad condition that came and passed away. And he received a letter from the lawyer for the client, and they were requesting for the full medical records. And then my first question was, are you able to get all the information back door? And it was amazing, because if you have such a system that you cannot get the information that you are putting in as whole as possible for other purposes, then that becomes a challenge, because you cannot carry a whole system to court if the court is asking you to produce, okay, the records of, let's say, a patient who has brought a case in court. So that is very, very important. And that information must also be accessible. What that means is that the information must be available anytime you want it. So if you get that documentation into that electronic system, you should be able to, for all intents and purposes, have access to that information when it is needed. So now let's look at medical report. What is it? If we talk about medical report, what essentially is a medical report? Well, a medical report on the outcome of is an outcome of a medical practitioner professional encounter, as I referred to earlier on, with a client or a patient that documents that encounter from the time you met the client, your history or examination, investigations, treatment, and then the current status, any other further treatment, like rehabilitation, whatever. Okay, so it's like that history, that chain of interaction and its outcome that has been put down. Okay, and it can take several forms. You can have a medico-legal report, which is what in our environment mostly we tend to hear about. But most of the time, what you must bear in mind is that every documentation that you put down in our field of work, okay, come in handy when it comes to legal matters. We can have a medical incident report. In our facilities, I know there are facilities that have, incident reporting forms. Okay, so in a hospital, a patient comes in, maybe patient is on admission, falls from the bed. Okay, you must produce an incident report. There is a format you may need to follow. The hospital may have its own format that you need to follow. You can have medical status report, medical annual report, for a patient, a narrative report, and a patient progress report. All these forms are forms of medical report that, you can have. Now, when it comes to preparation of medical report, this one with emphasis on, let's say, a report that is going outside a facility, there are things that you may need to bear in mind. Because a patient has autonomy, okay, and also in our laws, patients and their encounter with physicians, okay, are sort of kind of privileged, okay. You will need the consent of the patient to be able to issue such report. Because mind you, you cannot send out a patient's medical records without them knowing, unless under certain exempted situations. So if you look at the Public Health Act of Ghana, it talks about an informed consent. And just a brief part from section 167, it says that the principles contained in the 6th schedule shall apply to all persons who relate to patients or clients. And this is what the 6th schedule talked about. That is our paragraph 8 says that the patient is entitled to confidentiality of all information obtained about a patient. And that information shall not be disclosed to third party without the consent of the patient. This is in our laws. Or the person entitled to act on that consent, except where the information is required by law or is in the public interest. So those are the exceptions. So as we go down, you get to realize that there are times that a court will order that a person before the court is brought for medical examination. In such a situation, you don't need a consent of the patient to send a report to the court, because that report is being requested on the orders of the court. All right. And then you also get to realize that when it comes to insurance reporting in some of the medical reports that you send, if you pay attention to the insurance subscriptions, you realize that you may be requested to also consent that by subscribing to that insurance, you are consenting that the medical personnel that will take care of you will have the right to send your report, because that will be needed as part of the processing of that insurance claim. So you essentially have given your consent during the process of signing on to that insurance. Now, also in our laws, like I said earlier on, there are certain communication that may be privileged. Okay, and one of them that is stated specifically is when it comes to issues of psychiatric psychological treatment. When patients go through psychiatric treatment, the law says that that conversation is also privileged, and that cannot also be disclosed without the consent of the person. But essentially, a similar exception also applies And that happens when that person is trying to rely on the psychiatric or psychological condition before the court. In that case, you invite the court to also make inquiries or inroads into that condition without requiring your consent. And then another exception that is quite common is when you hear that a court orders that a person that has been brought before it is sent for psychiatric review because maybe the person has gone to commit murder or killed somebody. And if you look at or listen to the surrounding situations, it sort of brings up an issue or a question about the person's mental status. And in that situation, the court can order that that person be sent to a psychiatrist for a psychiatric evaluation. Under such situations, that privilege does not hold. Now we look at some essential parts or components of a medical report. So if you're issuing a medical report outside a facility to, let's say, an external party, what are some of the things that you probably may have to pay attention to? There may be a reason for issuing a medical report. And let's bear in mind that some of these reports actually can come in a standardized form, in which case, I mean, most of these would have already been provided for in terms of the places where you fill it in. And also, in this day and age where a lot of things are being done electronically, it may come also in a standardized form, but in an electronic form. But it doesn't take away anything from how it is supposed to be done. So you may look at the title, then the information about the patient, the name, age, essentially the biodata, gender. Then when you saw the person, the duration you mean for which you've seen the person for. And then the medical person who is preparing the report. Here, it is almost always important and crucial that the senior-most person of the team, okay, signs that report off. There can be situations where you may even need a medical board report. And as we go down, I'll make reference to some court cases where things of that nature, came up. So depending on the situation, okay, the person who probably signed it off may change. Then the purpose of the report, then obviously you will go into the whole history from the time you saw the person, what has gone on, diagnosis, prognosis, procedures, any interventions that have been done, rehabilitation, and of course, your opinion or your recommendation at the end thereof, because that is why you are giving that report. You are a professional, you are an expert in your field. So after putting everything together, what you think, your opinion, objective opinion, a recommendation about it is also crucial. And in some situations, you may even need to even attach certain, charts, that are produced within a facility to it if it becomes necessary. So here we have a case of a medical report that was tendered in a case. I think this had to do with a health practitioner. Okay, she was Mrs. Ansa was a DDNS, a nurse, okay, in one of the Ghana Health Service facilities in Takoradi. And she received a letter from the Director of Health Services to attend a program at a different place. And on her way, she ended up having an accident. Some way, somehow, it appears that though she might have qualified under a certain law, which we'll talk about later on, the facility never made that attempt, okay, to bring her under it and give her the compensation that deserved. But my emphasis here, why I picked this part of that judgment, has to do with the essence of medical report. What the medical reports that were submitted to the court did. It actually helped the judge in arriving at his decision. So if you look at the report, this is what the judge said as a part of the judgment. That from the medical reports tendered in evidence by plaintiff, there is no doubt that the plaintiff has suffered permanent incapacity. For instance, in the medical report dated November 7, 2019, two medical officers made some findings and a recommendation to the Regional Director of Health Services regarding the incapacitation of the plaintiff. So here you realize that it wasn't even done by one person. It was more like a team. And as we go down, you realize that it was actually a medical report that came from a board. So the court said that the findings, these are the findings. They just quoted a part of the medical report. And the findings were stated clearly. The patient is wheelchair bound because she cannot walk. She has a left foot drop, typically from a common peroneal nerve injury, and muscle atrophy, a skin graft over the site of avulsion, which has not healed completely. There's a skin graft. Right little and right fingers are deformed with only limited active flexion and extension. Currently, she is being seen at Kolebu on outpatient basis. And then they added a recommendation, or as we read, you get to realize an opinion. So as a result of the above findings and the long-term complications, the board assessed incapacity. So you realize that it wasn't a one person thing, because if you look at the accident, if you read the whole case and look at what happened, the treatment went on for a long time. And that's one thing that you have to pay attention. You shouldn't be in a rush, okay, when you are dealing with a complicated situation in trying to issue certain reports, when you know that very well things can actually take a long time. So the incapacity was assessed, and this helped the judge to have a clear understanding of what was before him. And then he was able to, based on the back of this report, make the right, judgment and award the necessary compensation. Now we move into the next step and the next arena of insurance report. Now, when it comes to insurance, typically what we talk about essentially has to do with health insurance, like NHIS as we know, and then the private health insurance, which all fall under the general health insurance as we know it. But then there are other forms of insurance that come into play. And one of them, as we'll talk about here, is workman's compensation, which is actually prescribed by law. Then the other form is also the personal or general accident insurance policies. And we will take these subtypes one by one. So under the general health insurance, like I said, NHIS, the various private health insurance policies that we have, they all have forms. Now the NHIS has moved from the paper submission of claims to online. I think the same with most, if not all, of the private health insurance. And then when it comes to the personal or general accident insurance policies, the various insurance companies also have their forms that sometimes they use. But in addition to the forms, you must bear in mind that there are situations where you may be requested to add more information, and nothing prevents you, okay, from adding more flesh aside the forms that your client may end up bringing to you. Then we'll talk about the workman's compensation, which I said is provided by law, and which is essentially a legally sanctioned insurance under our laws. So we look at general health insurance. Essentially, it is an entitlement, okay, in law, that a person is reimbursed for the cost that he or she incurs, generally because he has a contract with an insurance company. So yes, everybody can get sick, all right? And if you get sick, you are the person who is sick, so you take care of yourself. Somebody sets up a company and say, look, I know you can get sick. You can't tell which sickness you can get in the future. But then if you pay me this amount on a regular basis, which we call a premium, when you get sick, I'm going to take care of your costs up to this level, depending on the contract that you have with the person. That is essentially what this is about. And you realize that in the agreement or the contract that you have with those companies, there may be specific disease conditions that are covered and those that may not be covered. So for example, if you take, let's say, the National Health Insurance Scheme right now, there is an ongoing debate and conversation about roping in dialysis and several other cancer, conditions. So as the NHIS stands now, one can say that the NHIS does not cover dialysis. It does not cover all cancer cases. So then when you subscribe, you know the conditions under which, when you fall sick, you can be reimbursed, and those that you cannot. The same thing applies to other private, insurance companies. So, but then as a practitioner, okay, when it comes to your reporting, okay, in giving your report, that is not something that affects the way you go about your report. Your duty is to report your encounter with that client. What is covered and what is not covered is captured under contract between the person and then the insurance company. And of course, as we know, claims are based on tariffs and rates that are agreed upon by the insurance company and then the person. Sometimes and then the service providers. So if you take one insurance company, you realize that the tariffs that are paid are across the board for all facilities. It's all because that has more or less been agreed in the background. In some countries, they have committees that actually do that, especially when you are dealing with a non-facility kind of insurance base. So this is just an example of the old NHIS form that was used for insurance reporting. If you look at it, you realize that there's a portion that talks about services that have been provided. Okay, you go down, you see procedures that have been done and all that. It's all taking care of the encounter that you have had with your client from the point of history to everything that you have done, so that you can end up, getting the payment that, sorry. And this is the second page of that same form. Now, I picked this one from the National Uniform Claim Committee of the United States. Okay, that is also another form of insurance reporting, the standardized form. And if you look at the bottom, you realize that there is a statement that reads that point 12, where the case says a patient's or authorized person's signature. I authorize the release of any medical or other information necessary to process this claim. So essentially, you need the consent of the client or the patient to be able to go ahead with that, as I mentioned earlier on. So consent is important. But like I said earlier on, this one, the NUCC is mostly non-institution based insurance claims. So mostly in our setting, when you subscribe to these private health insurance, what you essentially do is that you may consent to having your medical history or part thereof being submitted, because that is needed for the claims to be processed. So essentially, you have given your consent. In the absence of that, you will need a consent of the client to be able to proceed. Now, the world keeps getting technologically advanced, and there are a lot of changes in the space, even in the insurance space. So what does this do when it comes to our work as a physician and dentist, as far as documentation and reporting are concerned? We have financial technology or fintech companies and several electronic payment platforms. Okay, we have the telcos that are coming into the insurance space. I'm sure, if you open your radio, you may hear a lot of adverts about short codes, subscribing to health insurance and other forms of life insurance and several other insurance, compared to what we know traditionally as probably going to an office to subscribe to an insurance. These things are essentially making the work easier for the insurance companies. But what it also does is that it is changing the landscape of our work in terms of how the reporting is supposed to be done. It does not, however, change the requirement of being diligent and being professional in what we report. So mostly we're shifting from a typical paper form to electronic. And when you have the fintechs involved, what is going to happen is that most of these reportings are going to be electronic, but then the standard must also remain, because it doesn't change the standard. The effect is that the requirements do not change. The same diligence is required, as I said earlier on. But it may require that you issue a medical report for claim payment electronically, but then you still have to remain as professional as possible. Now, the second leg, as I mentioned under the insurance, we're looking at general personal accident insurance policies. This also may not cover all insurance, all injuries. It's also contractual. So what is captured in that agreement with the insurance company is what will be covered. So, for example, if the insurance doesn't cover when probably you are not at work or you go on a frolic of your own, when something like that happens, definitely you may not be captured under that. As we go down, we will get to know. They will probably be standardized like the earlier ones that we've talked about, or maybe generic. Mostly generic will mean that you will have to report using the format that we talked about, using the topic and everything. You literally writing it like in the form of a letter or a normal report. But then if it's standardized, it comes in the form of a form with spaces where you can fill in. And of course, the consent still applies. And sometimes you may even need a police report, okay, as part of the report that you write. So I picked it from online. This is from Star Assurance. And you realize that this is a standardized form for reporting. Apparently, it's supposed to make your work as a physician a bit easier. But then, like I said earlier on, nothing prevents you from adding more flesh if that will end up, okay, putting across what you are trying to say. So this is the first page of the personal accident claim form. All right, this is more of biographic information. But when you go to the second page, there's a part that is for the medical authority or the medical officer. When they start talking about when did you first see the injured patient. So it's taking you more or less through the point of first encounter, history taking. They briefly state the injury sustained by the claimant. So if you look at this space and you think that this cannot, accommodate everything that you need to state, nothing prevents you from probably adding more information on that sheet. All right. And then you look at the bottom, you realize that you will need to provide the address of the facility that you are in, and then importantly, your signature and your stamp. So this is going to go on record as you haven't done it. And mind you, this is a legal document. It can show up in court. It does many, many times. So your level of professionalism is very, very important. You stay as professional as possible, remain objective as possible, okay, when it comes to filling of these forms. Then the third leg is what we call the workman's compensation. We don't hear much about this because in recent times, like any other risk that can be insured, most institutions or companies end up, offloading this risk to insurance companies. So the Workmen's Compensation Act of 1987, that's Act 187, literally says that if somebody is in your employment, okay, and the person sustains an injury in the line of their employment, in the course of their duty, the employer, okay, is bound to take care of that person's hospital costs as well as payment of other compensation. And there are specific instructions on how to even arrive at the entitled compensation as stated in the law. And there are also certain timelines that need to be followed when it comes to the processing of claims under the Workmen's Compensation Act. And as I referred to the case of Rosansa earlier on, that was one of the things that was raised by her lawyers. That despite the accident has happened several months, the Ghana Health Service refused to report to the nearby labor officer for the Workmen's Compensation Act to kick in. So if you are, let's say, a medical superintendent of a facility and you have any of your healthcare professionals, okay, or any of your people working under you sustaining an injury in their line of duty, there is a responsibility on you, okay, to make sure that this is done. Now we come back to the case of Rosansa again, and this is a saying by Justice Richmond Osei when he was giving his judgment, and this is a profound, observation that he made. He said that this suit relates to workmen's compensation claim. Workmen's compensation is a statutorily mandated program that provides benefits to workers who become injured or ill in the course of their employment. It is effectively a disability insurance program for workers. So essentially, the workmen's compensation, which is covered by a whole act, is essentially an insurance, okay, providing cash benefits, healthcare benefits, or both to workers who suffer injury or illness as a direct result of their job. I think that the issue of workmen's compensation is not really dealt with enough when it comes to health workers, our understanding. And probably I will use this medium to more or less advocate and plead with medical superintendents and heads of institutions to probably pay particular attention in training their healthcare workers, especially those who come into contact with workers, hazardous work, so that they are more, versed in how to do their assessment. Because sometimes it can be disheartening when people suffer certain injuries and you see the kind of calculations and computations that come out. So this is from a section of the Workmen's Compensation Act. It talks about how the computations are supposed to be done. Where employees sustain personal injury by accident arising out of or in the course of employment, the employer is liable, subject to this act, to pay compensation in accordance with this act. And then the person who is injured shouldn't have his or her salaries reduced whilst he's still under employment when that thing has happened. Now, when a person comes in to the medical officer, okay, it needs to be assessed and the level of incapacity arrived at. But mind you, the level of incapacity may not be a one-time thing. It can be continuous. If you remember the case of Rosansa, as I referred to the report that was sent to the court, you realize that though the accident happened several months, her conditions continued. He became wheelchair bound, he lost limbs, he couldn't walk, and that did not happen just within days. It happened over time. And so the Act also recognizes that, and therefore you can actually issue a preliminary as well as a final report as far as your assessment is concerned. So don't be too much in a hurry when it comes to completing your report. You need to be as factual and objective as possible. And like I said earlier on, if it comes to a point where you actually need expertise from people, specialists, you are allowed, okay, to do that. You don't have to, because you saw the person first, you end up writing when you realize that this is a clear case of, let's say, orthopedics or neurosurgery, and you need somebody who is a specialist to do in-depth assessment. Okay, nothing prevents you probably from doing, your initial encounter, giving a referral for that person to go see that specialist for them to do that in-depth assessment. I remember when I was working in Tema, there was a case like that. As a young man, I was working in one of these industries, had an accident, came in. I saw him a couple of times after requesting for certain investigations, and when the report came, I referred him to go and see an orthopedic surgeon, and he wasn't happy at all. He wasn't happy at all because he thought it was becoming, it was more of a stress. But then the truth of the matter was that at that point, the condition went beyond my expertise, and it needed, the input and the eyes, of an expert, a specialist who is an orthopedic surgeon, and for that matter, that was needed. So, despite the fact that he wasn't happy, he still had to go, because then, if he refuses to go, the Act provides for that. If the person refuses to go, it is going to affect the final, report that will go out, and you need to be professional as possible and do what is right. Now, the Act also provides for compensation in terms of fatal cases. So when a person dies, there are ways in which you, excuse me, sorry. So if a person dies, there are ways in which you go about the calculation as well. Okay. But the key thing that we would need to look at here is that when it comes to the reporting on the workman compensation, I just highlighted this point. Okay. When in an employment personal injury of the description specified in an entry in the first column, blah, 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 occurs, compensation, the employer shall pay as compensation an amount of money for the injury determined by a medical practitioner recognized by the government. I'm sure you might have heard that nowadays when you go to court, the first thing from lawyers from both sides is to make sure that you have the right license. If your license has expired, have not renewed, it means you didn't even have license to practice in the first place. The same thing happens even to lawyers. You're going to court, you've not renewed your license, you'll not be given hearing, and the case of your client probably will just be thrown out. If you are a medical practitioner who is not licensed, recognized by the government, essentially means that here you have the proper license and to practice. Okay, and by extension, okay, will mean the proper qualifications and the proper skills. So if somebody sustains an injury that falls within the domain of orthopedic surgeon, you cannot sit because as a medical officer, the first person who saw the case, there and try to make certain decisions, make certain pronouncements when you know that you don't have the requisite qualification to make those decisions, because it is going to really affect the outcome at the end. So the issue of getting the right skilled people involved is very, very crucial. And as I mentioned earlier on, there are timelines that are involved when it comes to reporting. So within 6 months after the happening of the injury and before the employee has voluntarily left the employment, that is when there's certain reporting. Within 7 days, the employer is supposed to report it to the labor officer. And then there are other timelines that go on. So, well, that one may not affect the work that you do, okay, as a physician. It is when it comes to you. So the takeaway point from here is that knowing very well that there are timelines involved, your documentation in terms of dating and timing is also very, very important. Very, very important. There have been court decisions that have centered on just dates, because that's where the contention comes in. So knowing very well that time is of essence, your date when you first saw the patient, the various reviews when they took place, when you refer the patient to go and see a specialist, when the patient actually saw the specialist and came back with the feedback, all those things are very important because they are going to go into the final report. That is, if you so happen to be the person who will be doing the final report, or you are part of maybe the team of doctors or a medical board that may end up issuing that report. Your documentation in terms of timelines are also very, very important. And as I mentioned earlier on, if you look at this subsection 7, it mentioned that the normal medical treatment includes a specialist treatment which the medical practitioner may require, as I made reference to my own personal experience when I was referring him to go and see the orthopedic surgeon and he wasn't amused at all. If it needs to be done and there's a professional indication, that needs to be done because that is crucial and is going to affect the outcome. Now, this is just to take us briefly through the various assessments in the Act. So if you look at the Act, the Workman Compensation Act, it provides at the back of it, okay, percentages relating to certain injuries. So for example, if you have somebody in the line of your duty sustains a mutilation or amputation of 1 ear, you assign 15%. And this percentage of injury goes into the computation or the compensation that the person will get. Same with what is stated here. So conspicuous deformity of face, generally that's 50%. Functional loss of genital organs, 85%. You come here, loss of 2 limbs. If a person loses 2 limbs, let's say in an accident, person is going for a function that is sanctioned by their work, ends up in an accident, sustains an injury, loses the limbs, that is 100% of incapacity. Loss of both feet, the same thing. Total paralysis, same thing. And these are other ones. Loss of leg below knee, that was 60%. So this is how some of the forms that you probably will encounter under the Workman Compensation looks like. Sorry, I had to redact this because it had information of a client who unfortunately passed away. So there's a portion for the employer who will fill the detail, and the employee's detail will be there. Then there's a part, the first part here, that states that that is a medical practitioner of this facility, I have today examined the above mentioned employee. And then you go down, you see I did not treat this case at the time of the incident. The timeline that I'm talking about. So if you see the person, the very day that you see the person, you need to document, because the injury might have happened probably 2 weeks earlier. And what you are seeing today will be different from what it was the day that the injury happened. As practitioners, we know. Okay, that time is of essence when it comes to things like that. Then the nature of his injury as at the time that you are seeing it, you need to describe that one in that portion. And you go down, it says he became fit for work again on. If that does not, okay, fit at that point in time, if the person is still unwell, you have to cross that part out. Okay, so any part that, I mean, is inapplicable, you cross it out. And then you come down, that's where the level of the assessment of the incapacity come in. So you see where the case is under section 4 and 6. It says that I assess incapacity at. So based on the injury that the person has sustained, okay, the chart that I showed earlier on, you can give an assessment of the incapacity. And then you can determine whether the incapacity is permanent or temporary. Like I said earlier on, there is no rush in trying to determine that the incapacity is permanent when, based on what you have seen, you realize that things are going to take a while before that decision can actually be made potentially. So you are allowed to do an initial assessment. So if you look at the top part, the part A, you realize that you see first/final medical report on incapacity. So there can be an initial assessment, and then a final assessment can also be done. Then I also assess disfigurement at a certain percentage, okay? And that one can also be put there, which will eventually inform how the compensation will be arrived at. So that is essentially how the form looks at. The other part of the form that is not meant for the medical practitioner. So the same thing applies. So for example, if you are, I've started a case of a trauma, you get a lot of people getting facial injuries. Same thing applies. If you are a dental practitioner, a dental surgeon, okay, if you see the injury and you think that this injury obviously needs a maxillofacial surgeon to come in, sometimes it's difficult because where you find yourself, maybe a far distance, getting this person to maybe come to Kolebu to see a maxillofacial surgeon. But then, if you look at the situation, you see that that is the right thing, that is a professional thing to do. You need to let the person know, or the relative know, this is what needs to be done, okay? And then make sure that they get the right treatment so that at the end of the day, you may be able to give a proper account, a proper report of what has happened. So this is for the employer. The employer fills this part and then signs. And then this part 2 is for the employer to report. Okay. So now under the Workmen's Compensation Act, just a brief report on a case that was brought here. Now, this was a case involving a tipper truck driver who was carrying cocoa product from a place in the Central region called from Jaboso to Kumasi, and had a head-on collision with a Benz bus, what we popularly call a 207, bus. And essentially, the driver ended up sustaining several injuries, couldn't drive again. And when the case was brought, apparently because the driver was working for his company, the right, or should I say, one would have expected that probably because he sustained an injury in their line of duty, he would have only brought himself under the Workmen's Compensation Act. But he didn't. And this is to buttress the point that though the Workmen's Compensation Act is there, nothing prevents people from taking other actions, i.e., trying to bring a case of negligence against another party. And your report under the Workmen's Compensation in terms of the injuries and your computation of disfigurement, incapacity, will also still be necessary to assist the court in arriving at the compensation to award. So in this decision, in arriving at the decision, the court said that in arriving at the percentage of incapacitation, I made reference to the Workmen's Compensation Act. The loss of limb below knee, and this is an account of a medical officer who wrote the report. And he was actually summoned to come and testify in court. So like I said earlier on, the reports that we issue are legal reports. we can be called to speak to them in court. And that is why your professionalism and objectivity is very, very important and very crucial. Because as we go down, you get to realize that this person, yes, issued a report, but when he was before the court, he had to sort of change his stance a bit when other evidence were brought before him. So in arriving at the percentage of incapacitation, I made reference to the Workmen's Compensation Act. The loss of limb below knee is 60%. Loss of limb above knee is 75%. Loss of the foot is 40%. I gave the patient 45% at the time, that is the doctor speaking. I reviewed him, gave him antibiotics to stem the infection, and hoping the non-united bones will unite. I did this with the then head of the department, Dr. Peter Kunedu. So the issue of getting a superior person involved, you see, it adds credibility to whatever you are doing. And this is how I arrive at the 45%. But as we sit here, the limb needs further surgery. So you see, if he issued this report as a preliminary or a first report, obviously there wouldn't be any issue, because then when further treatment has happened, they can issue the final report. As I sit here, I do not think he has his leg, and in reference to the Workman Compensation Act, this loss of leg below the knee is 60%. That is my opinion as I sit here, but the percentage will have to be determined by a team of doctors. Clearly, as I sit here, I know that the 45% is not a true reflection of his incapacitation now. So just to buttress the point earlier on, one, getting a superior person involved adds credibility to what you're doing, because especially if a person is a specialist, they have knowledge of the field that they are assessing. Two, there is no need to rush in issue a final report. I am presuming that this was a preliminary report, and as he admits, the doctor is put before the court, admits by evidence that the leg will need more work. And obviously, the 45 that probably was given earlier on will not stand and may have to go up. So essentially, that is how it works. And like I said earlier on, like any other insurance, okay, that can be bought, or any other risk that can be, taken over by third parties. Workmen Compensation Act, the provision under the Workmen Compensation Act can also be taken on the risk that, entities or companies are supposed to bear, okay, can also be offloaded to third parties, i.e. insurance companies. And insurance companies also have policies to do this. And I picked this from online from Hollard Insurance, and they have what they call the Workers' Compensation Insurance, which essentially is the provision under the Workmen Compensation Act. So essentially what they are saying is that if you are an employee, a company or a business, okay, you know that this is what the law says when it comes to your employers or your employees. Instead of waiting for it to happen to your employee and you bearing the cost, you buy their policy of an insurance company that provides this kind of insurance cover. Pay the premium so that when it happens, instead of you paying directly from the coffers of the company, the insurance company steps in. And by doing that, what it means is that there may be further reporting that may be requested from the insurance company, okay, in fulfilling the requirements so that it can make that payment. So we must bear that in mind as well when we are doing the reporting. So this is a sample of a workman compensation claim by an insurance company that probably may be attached or in addition to the forms that were shown earlier on that may need to be filled. So we now look at the last leg of our conversation for the day, which is excuse duty reports or doctor's note. This is an internal memo which unfortunately found itself onto the World Wide Web by one of Ghana Health Service institutions, and it raised a very interesting discussion. The title is Policy to Streamline Acquisition of Excuse Duties and Granting of Sick Leave to Staff. And he said management has noted with grave concern the arbitrariness, abuse, and lack of adherence to the policy and guidelines regulating the acquisition of excuse duties. and granting of sick leaves to staff, and its adverse impact on productivity and performance of the service. Accordingly, because of the above, certain measures are put in place, and staff are told the kind of excuse duties that will be accepted, what they need to go through to get a proper excuse duty. All valid excuse duties must be acquired from government-approved health facilities. All valid excuse duties must be endorsed by, a certified medical practitioner in good standing, and all excuses must be submitted to the hospital immediately upon acquisition. So excuse duty, can be quite a dicey situation, particularly when it comes to issue of employer and employee relationship. What does it do essentially? So I just took this picture from Adam Online. This is a former General Secretary of the Ghana Medical Association, Professor Titus Bayu, in a conversation. And this is a news item that says, former General Secretary of GMA warns against unwarranted excuse duties. Unwarranted is the watchword here, unwarranted excuse duties. Why should excuse duties become so much of an issue, even within institutions of health that people work, as well as for the general public? Ideally, one would think that if somebody is sick, what everybody, a well-meaning person will want is the person to get well. And that's essentially what an excuse is supposed to do. It's supposed to help in our recuperation and in our recovery. And if there's anything that COVID has taught us, is the fact that there are certain diseases that sometimes can even spread. And so, if somebody is unwell, especially having a communicable disease, an excuse duty can help make sure that the person does not bring it to the office or the workplace and spread it to more other people. Another purpose of an excuse duty essentially also is to seriously fulfill an employer's request, where if an employee is not able to show up to work, there must be evidence that the employee is unwell and the person is not literally just trying to avoid work but getting paid. And other places too, it's a way of excusing people from mandatory jury duties, so that if you're appointed as a jury of a court and if you're not well, you may need to show an excuse duty. Now, when it comes to excuse duty, for our purposes, what are some of the considerations that we need to bear in mind when issuing an excuse duty? The first and foremost is you should never issue an excuse that is open. And I recount a story that was somewhere in 2012. It happened to a colleague of mine who ran to me, in a very desperate situation because things were being escalated. And what had happened? She attended to a friend of hers who worked in one of the prominent companies in Accra and gave her an excuse duty. So in writing the excuse duty, you put a date and everything there and give it to the friend to write 3 days on it. The person took the excuse duty and wrote 30 days. Now, this form or this report got to the company, and then they called the hospital's administration to find out who issued the excuse duty. She couldn't deny that she didn't do that because, one, your signature is on it, your stamp is on it. All right. And if there's 30 days on it. So obviously on the face of it, you did issue the excuse duty. So the lesson here is that you will never leave things open when it comes to your excuse duty form. There have been instances where people have even manipulated what is written on the excuse duty. So as much as possible, when you are writing, if you are writing in the duration, you can write it in words as well as figures, so that it leaves nothing beyond doubt. Another consideration is that you should be mindful, and the duration you are issuing should be commensurate with your professional qualification and tie in with your institutional practice. When I worked in one of the Ghana Health Service institutions, there was more or less an institutional practice that said that if you're a house officer, you couldn't issue excusability beyond 3 days. And it does make sense. It makes a lot of sense because if you are working as part of a team, okay, and certain decisions that are supposed to be taken at specialist level, that will require certain level, okay, of superiority to be able to give certain number of days. You can actually put yourself in trouble by doing that. A typical example that comes to mind is if you take our labor laws, it talks about a medical officer that takes care of a pregnant woman that go through a complicated delivery can extend the maternity leave, which for all intents and purposes is an excusability, by 2 weeks. Okay. Now, if you're a house officer and you go and sign, okay, an excusability for 2 weeks for such a person, okay, it can raise certain queries, especially if issues come up later on. Okay. But of course, I mean, if you are doing it on behalf of your superior, that's a different matter. But if on your own, you go and do such thing or issue an excusability of 1 month, like I said, I stated in the earlier example, that can actually put you in trouble. So, one, pay attention to your level of qualification as well as your institutional practice and standards. Another thing is you have to be mindful of the diagnoses that you indicate on the face of the excusability. There have been issues of stigmatization and can come with legal implications. Let me take a typical example. Let's say somebody works for a company or institution where, I mean, being able to, have a good sight is crucial. The person start developing an eye problem, okay, that has not been determined yet to be maybe something permanent that can affect the person's sight. The person comes to the hospital probably coming to do an assessment for, let's say, glaucoma or any other eye condition. And then based on what the referring physician writes on the request form, maybe assessment for glaucoma on account of query, blindness or whatever. That's supposed to be a communication between physicians. Now, if you issue an excusability and you go and put a, let's say, diagnosis on the face of an excusability that is going to a non-medical environment, you could actually jeopardize the work of such a person. There is no requirement on you to write specific diagnosis, especially if they have a risk of putting the other person's work. I mean, they have a tendency to put the other person's work at risk. Mind you, as we said earlier on, the interaction between a client and a physician is a privileged one. Without a person's consent, you do not divulge certain aspects of the person's medical history to third parties. And in a situation like this where it can imperil the person's work, it can stigmatize the person. So we need to be mindful on what we write on the face of it. That is very, very important. Then another consideration we need to bear in mind has to be with our professional and non-arbitrariness. If you look at the internal memo from the public health facility that was shown, it appears that like everybody was bringing an excusability, okay, and now you need to more or less like, weigh things, okay. Are you just giving an excusability because the person is a friend? Okay. Are you giving it because probably you just feel like, oh, he has a program somewhere and he cannot attend, and so you give an excusability? There's a reason why your stamp carries weight. There's a reason why your signature is respected by the state. There's a reason why the state has given you that license to do that work. Okay, it puts on you, okay, with that license, a responsibility. And that responsibility in carrying out your work should not be exercised, anyway, anyhow, arbitrarily. So before you can go ahead and issue an excuse duty, you should have actually seen the person, or should have been a client that you know already. Not that a friend calls you and says that, oh, my relative has traveled from US, UK to Ghana, and he cannot go, and his or her work will be in peril. Can you issue me an excuse duty? You don't even know who that relative is, but just because the person is. And I'm sure that if we were to ask people here, a lot of people get that calls a lot. And that is where your professionalism and your credibility comes in. Mind you, there have been instances like that where people have called from countries outside. And such situations, some of them have almost found their way to the corridors of the regulator, the Medical Dental Council. All right. And the truth of the matter is that when you are being taken on, you may not know, because the communication will happen between that institution and probably your medical superintendent or your medical administrator. You get it. And sometimes they may even go straight away and go and report you to council. So we need to be very, very careful when it comes to those things. Yes, it's good to have networks, it's good to build relationships with people, but that does not, or that should not make you compromise on your professional integrity when it comes to doing your work as a physician, when it comes to doing your work as a dental surgeon. And it obviously must be within prescribed, legal limits, as I made reference to the Labor Act that talks about maternity leave and its extensions. Now, this is a very interesting picture. Must excuse duty be requested at all times? This is actually a true excuse duty that was issued by a doctor in Canada, in Alberta. A worker who felt that she was not well, had a common cold, decided not to go to work, informed their employer. Her manager asked her to go to the hospital and go and get an excuse duty. And of course, that brings in the issue of ethics, as we're talking about here. And the physician who attended to her thought it wasn't really necessary. And around that time, there's been a lot of conversation going on about unnecessary requests for excuse duty for the slightest of things in places like Nova Scotia and co. And there's been a pushback from physicians as far as the onerous demand by institutions and companies for excuse duty at the least sickness of their employee. So the doctor writes, to whom it may concern, this person K has had, by their own report, a cold today and sensibly stayed home from work rather than spreading this to his colleagues / customers. I have no test for the common cold and therefore believe him or her. However, you feel his time and mine should be wasted by making him sit in the walk-in clinic for hours and me spending time writing a sick note that I could be spending on people who genuinely need my attention. Please reconsider your policy on this. There are surely better ways of wasting your tax dollars. So this is, if you listen to the tone of this is a very unhappy, an annoyed physician who thinks that a company's demand for excuse duty at the least sickness or wellness of their clients is a waste of everybody's time. And that brings in the issue of the ethics we talk about. We cannot have right or wrong answers for some of these things. But when it comes to how we relate, particularly for institutions where you have corporate entities coming, assessing medical care from your facility, it becomes necessary to have this kind of conversation with such institutions. Must excuse duty be requested at every point in time? Will it be appropriate for those institutions to have certain policies, that let's say a person is not feeling well, has a cold, as in this state, or let's say somebody, a woman of productive age, is having dysmenorrhea, does she need to go to the hospital necessarily to go and get an excuse duty? Or she can just communicate with her superior, and then the policy that has been put in place will kick in without necessarily, spending all that hours. These are things that there are no specific answers to. Because on the other side, the argument will be that how then do you determine that this policy that has been advocated for will not be abused by staff, so that eventually when people are actually requested to go and get SQDT, they want to bring themselves under that policy. So these are, debates that are happening in other jurisdictions. And as you can see, certain practitioners are unhappy, but sometimes you realize that your hands are tied and there isn't much that you can do about it. It can only, happen through dialogue, especially for facilities that deal with institutional clients and their employees. Now, we've talked about a lot of issues to do with professionalism and exercising professional conduct in our reporting. And when you talk about even the excuse duty, as I've mentioned, with the coming into force of the current act that regulates our practice, which is the Health Professions Regulatory Bodies Act, it has essentially repealed, or made invalid the old MDC Act that regulated our practice. However, we must bear in mind that though the Act repeals the Medical and Dental Council Act of 1972, it did not, and I repeat, it did not totally abolish certain rules, regulations that were passed under the old Act, and particularly rules and regulations to do with disciplinary procedures. And if there is anything that you don't want to do, is to find yourself at the disciplinary committee of the Medical and Dental Council, and I'll tell you why. So if you look at our current act, it says that despite the repeal of the old law by the new law, Part 7 of the Medical and Dental Act related to disciplinary matters shall continue in force as if they were made under the current act. So the issue of being charged with, informal conduct and all those things, we are not out of there yet. Unless, of course, there have been new developments and there are new regulations that have been passed that I'm not aware of. But as the law stands now, you can still be brought if you exercise unprofessional conduct. So you go and issue an excuse. That is why in the 2012 case that I cited about my colleague, she was so apprehensive, because obviously that would have been an unprofessional conduct. And trust me, it can actually get to a point of you losing your license. So please let us bear in mind. It may seem like you are just giving a note to a friend, to a colleague, but you must ask yourself, this 1 week note that I'm giving to a friend with no basis, is it worth my license that I've struggled for and toiled for all these years? After going through medical school for years, after going through residency, am I willing to sacrifice that on this altar of just this act because the person is my friend? It's very, very important. I had a privilege of being with a former senior colleague as representative for a lawyer before the Medical Dental Council Disciplinary Committee. And this was a doctor who, when he started practicing, had not even been born. So you can imagine the number of years the person has served as a medical practitioner. But before the disciplinary committee of the council, it wasn't easy. It wasn't easy. The kind of details is literally more like facing an inquisition, let me put it that way. Okay? Because you'll be shocked that you meet people, some of whom are probably senior colleagues that you might have interacted with before. But at that point in time, it is strict professional work. And I was amazed. I was really amazed. And I interacted with other people who were coming in for their sessions. Some of them have been so distraught. They had to probably travel outside for programs. They couldn't go and all that. Please, I'm just pleading. Let's pay attention to our professional conduct when it comes to this kind of work, when it comes to our documentation and reporting, particularly in taking decisions arbitrarily that can put us into trouble. Because I don't think it is worth losing our license and our practice over that. So in conclusion, I would say that proper and detailed documentation is the basis of a good medical report for whatever purpose. Our encounters with clients must always have the future in mind with respect to communication and documentation. Let us be professional and objective at all times. Don't let us allow familiarity to cloud our conscience and cloud our judgment and decisions. And there could be consequences of unprofessional conduct, taking the form of lawsuit for negligent behavior. Yes, indeed, patients can sue us, or even being subjected to disciplinary proceedings by the regulator, which is the Medical Dental Council. These are my references for this presentation. Thank you very much for your audience. Thank you. Dr. Salome, if you are there. Hello? Hello? Please, can you hear me?
Yes, Dr. Uswan, sir, we can hear you. Thank you
We
very
can
much.
hear you.
Good. Richard.
Yes, please. Yes, thank you, Dr. Uswan. Thanks for the succinct way you have captured various scenarios, because it's quite an expansive area. And thanks for also throwing light on many new things that we have noted. Let me quickly add, which I missed from the beginning, that this particular session, CPD session, is being chaired by Dr. Med Bernard Abegu Hammond, who is a member of the committee, the CPD committee of the association. So we will take some questions, and let me kindly check whether there are some questions here, and then we'll take them from there, please. So I'll take the first two, and then you can look at them and respond to them. Dr. Enesquesie J is asking, are autopsy reports considered part of medical documentation? Then also, somebody wants to know, does the GMA have the institutional provision for providing legal issues, such as assault of practitioners, citing the Suhun incident as an example? 2, should vaginal delivery require a consent form, considering that issues such as brachial plexus injuries can become legal battles for practitioners? What makes a consultation formal and legally binding, considering people would often ask for consultations via WhatsApp? So please, you can take these questions for now, and then we'll take the other questions in the chat, in the Q&A session.
All right, so thank you very much, Doc. So the first one on the autopsy report, yes, an autopsy report is part of medical documentation, and there have been numerous cases where an autopsy report has come up, to show the cause of death. So yes, that is for medical documentation, so definitely. Does GMA have institutional provision for pursuing legal issues, such as assault of practitioners, citing the recent Suhum incident as an example? I'm not so sure what has happened in Suhum, but when it comes to pursuing assault, an assault is a criminal offense, that is one. So if an assault happens, it will need to be reported. Essentially, the institution that may come in mostly will be, excuse me, will be the employer of that person, because I'm sure the institution will have its own way of dealing with issues. But bear in mind, assault is a criminal offense, okay, that can be reported to the police as such. As an association, at least I have witnessed situations where the association has sort of formed committees to, behind the scenes, work on certain situations that affect its members. So to that extent, I can say yes, the GMA does something like that. But for issues of assault, that's a criminal offense that would need to be reported. For the law to take its course, and then also use the various avenues that the institution that you work for has in place. So, for example, with the Ghana Health Service, I'm sure there are chains of reporting of situations like that. Should vaginal delivery require a consent form? Considering that issues such as brachial plexus injuries can become legal battles for practitioners. Well, essentially, I know places where, depending on the issues with the pregnancy. So if somebody comes in, somebody is pregnant, okay, you've assessed everything, there's nothing that goes against delivering vaginally. Okay, nothing prevents you from allowing the person to deliver vaginally. Mostly issues come up when, like what you are citing, the issue of brachial plexus injuries, when you are having problems that can actually increase the risk of having, let's say, shoulder dystocia, okay, and then you still go ahead. I have had been part of an issue where a lady who was supposed to deliver, the baby was big. Scans showed that the baby was big and couldn't deliver. Doctor counseled her several times. She refused. And her reason was that she's delivered a big baby before. Okay. So in such a situation, what the doctor did was that he made a sign, okay, that she wants to deliver vaginally. And the long and short of it is that this lady ended up losing her life. Okay, because she said, had a prolonged labor, and unfortunately, surgery couldn't be done on time, and they ended up losing her. So when you assess and those situations are there, nothing prevents you from letting them put it on paper in terms of consent. So that one, yes. And of course, there's nothing like over documentation. Let me put it that way. So if you want to put in a consent form for vaginal delivery, nothing prevents you. It just goes to add on more layers to your documentation. But also bear in mind that we know vaginal delivery is more or less a natural way of delivery. Okay. So if there are no issues that preventing the person from, delivering vaginally, that probably may not be necessary. But then adding it to it also doesn't take away anything. If for anything at all, it will just add to your protection as an institution. What makes a consultation formal and legally binding? Considering that people will often ask for consultation via WhatsApp. That's quite interesting. Yes, that's what I made reference to earlier on. Our landscape of practice has changed quite significantly with the advent of social media. And considering the fact that courts have held, okay, interactions and transactions that are conducted over social media like Facebook and WhatsApp as binding. By extension, you offering medical advice and those things over phone, over WhatsApp, can also be held as binding. What makes it legally binding? The fact that you are accepted to provide, okay, that service. If you don't offer your services over that, you make it clear that you don't offer. You can tell the person to come in. But now that we have telemedicine, a lot of things are happening online, obviously, that space is also recognized. And so if you go ahead and offer and do that, definitely you are owing a person a duty of care by way of the advice that you are giving. And you need to provide it, okay, to the same standards as allowed through that medium. Okay, there's a question here. In respect of consent in pre-employment medical report to be is pre-employment medical report to be consented to before one goes ahead to conduct same?
Yes.
If I understand this question, you're asking whether before you get employed, do you need your consent? Does the employer need your consent before you go ahead with the examination? Is that what he's trying to say?
I am thinking that from what the question is, how it's been put, it seems as though he's asking if you need consent before you perform, or should I say you undergo.
Oh, okay. So like somebody comes in for pre-employment medical examination.
Yes.
And you need to send a report to the employer. Right, definitely. You will need a person's consent. Because you see, under the various exemptions that we talked about, okay, an interaction between a client and a physician or a dental surgeon is a privilege interaction. Okay, so most of the time, I think what happens is that because the person needs employment, all right, by virtue that the person he himself or herself has gone for the form and brought it to you, okay, more or less like consent to that being done and reporting. I don't know whether you get it. So yes, you need a consent, but more or less that more or less become more like an overt consent of a sort. I don't know if you get what I'm trying to say. I don't know if that answers your question. So before you get employed in company A, the company requires that you do a pre-employment medical and submit. Now, if you want to be employed, then what you do is that you have to go follow what the company is directing. Your action of following to get that report done means that you are consenting to have that report sent to the company that is about to employ you. So yes, there is some element of consent there. If you can make it formal, all the better. Like I said earlier on, it protects you. It adds more layer of protection to you, the practitioner and your institution. And there are some forms. There are forms. There are some portions on some employment forms that I've seen that the would-be employer needs to sign to consent for that to be released. But not all of them have that. But there are some pre-employment forms that have that section for the would-be employee to sign and give that consent or report.
Thanks for the responses so far. Dr. Josiah Boateng wants to know some of the medical reports he has seen, the forms, have little space for full documentation. As such, summaries are usually what is written. And he wants to know whether such quote and unquote summarized reports hold in the court of law. Dr. Ezra Odonko also wants to know how the degree of incapacitation and disabilities are calculated, or how we come up to those figures that are assigned. Dr. Frederick Davo wants to know if it is right to write a medical report on a client you have not personally attended to. You can take these three questions now,
right,
please.
So, Dr. Josiah, yes, we mentioned earlier on that some of the standardized forms, because they are standardized, okay, will not give enough room, as you are saying. But then nothing prevents you from, adding more, sheets in terms of maybe you typing and adding it to the report to add more, because the more clearer information you're able to give, the better it will be before a court of law. So if you end up squeezing yourself into that space by giving inadequate information, you may find yourself wanting. So nothing prevents you from adding to that. Just make sure that it's also a formal thing that is right, signed, and dated. Then the issue of degree of incapacitation and disabilities. Yes, like I said, that is provided in the Act when it comes to the Workman Compensation Act. There's a whole section on that. Schedule on that when it comes to the percentage incapacity. So the framers of the Act, based on consultation, assign certain percentages to it. All right, but they are not fixed, as you've seen for some of the cases that were raised. When you go to court, sometimes depending on the full case before the court can actually take other opinions from other experts and maybe end up with something different from even what you have assessed. But your baseline is to use what is in the Act. And like I was saying, it will be better if institutions take it up and probably start, training practitioners on how to go about the Workman Compensation Act, especially for people who work in probably accident centers, major trauma centers, and what have you. Please, is it right to write a medical report on a client you have not personally attended to? Preliminary, the answer will be no. But then that will depend on whether you are working in a team. So for example, let's say you are a member of a team, okay? You may not all see one person at the same time. So if you are the one tasked to maybe look at the history and just draft the report for the team, That one is yes. But then even in that situation, like I said earlier on, is the senior most person of that team that is ideally supposed to, sign that report off. But then if you're talking about you being somewhere else and then you have no idea about what has happened to a patient, let's say a one-man station, and then you come up and you are going to issue that report, that is essentially not advisable. But you can also say that, there may be situations where, for example, the person who was at that station before you saw the client, maybe the person has traveled outside. What will you do? In such a situation, you can write a report but indicate clearly that you are just issuing a report based on what you have in front of you. Okay, because situations are not always, should I say, fixed. You get it? So in such a situation, if the person who was manning that station is no longer there, okay, what is available is the medical records that you have. You can either submit the records as they are or write a report from that record that you have available to you, but making it clear that you are writing that report based on the records from the person who saw. It will depend on, the situation in which that report is being requested. But then if the person who attended the person is still around, then obviously there's no point. You don't put yourself in that situation. Thank you.
All right. So I think these questions have been addressed. I have informed that on the YouTube, one predominant question that keeps coming up is the issue of excuse duties that we give to parents of minors. So for example, a baby comes on admission and the mother or father or whoever is the one who caters for the child is given typically the mother is given an excuse duty to enable her either attend to the child whilst the child is on admission or attend to the child at home. How legal is this practice, and how do we do it so that we don't get into any trouble? Let me take a few questions in addition, and you can just respond to that as well. Is it possible to include discharge against medical advice and its legal implications procedures in the future? That is well noted by the committee, and we'll look at that hopefully later in the year. Well, this question probably is a larger question, which is not necessarily for you, but it has to do what can we do because of the high patient to doctor ratio, which is wreaking havoc on all of us, meaning that you need to see a lot more patients, and so the time is limited. And the doctor, do or say things that it's having an effect on the kind of quality of notes and then probably reports that we write. So you can share your perspectives on that. The last one would be, would we say developing chronic diseases like hypertension as an employee is attributable to line of duty illness and hence eligible for compensation? So,
okay, so I think I will take the issue of the issue and excuse duty to a parent to take care of a child. I think in our practice, that's something that happens quite often, as you referred to. And from experience, what I've seen is that entities or companies actually request that you bring in, and that is because, you see, when you go back to our Children's Act, okay, when it comes to dealing with children, it says that you put the interest of the children first in all things that you do, what we call the welfare principle. So if a child is unwell, a child cannot take care of himself or herself, and the person who can take care of that child is the parent, then by extension, what you have done, you are incapacitating that parent. So I don't see anything wrong in issuing excuse duty to a parent because a child who is unable to take care of himself or herself is sick, and a parent will need to be there for it. I don't know if that answers the question. So I don't see any, legal justification for not doing that. There seems not to be anything wrong. It has been a practice that goes on, not only in Ghana, in other places it does happen as well. I don't know if that answers the question.
I believe that does.
Yes.
I believe that does. As I mentioned, some of them were not necessarily for you, but you can comment if you, for example, developing chronic diseases.
Yes,
that's quite a difficult thing to prove, but
yes, so that is quite interesting. I mean, it sends my mind back when we start talking about, let's say, what causes hypertension. We talk about issue of primary hypertension and secondary hypertension. All right. It will be quite difficult probably to establish a direct link between maybe the work that you are doing and the fact that it's made you develop hypertension. Aside the fact that you probably could be talking about issue of stress. Okay, but if you look at the act, it talks about disease conditions that you suffer in your line of duty. So a typical example that can come in here will be maybe somebody whose work requires, I think it was a case like that. Your work requires that you sit or you assume a certain posture for a long period of time, and then you start developing musculoskeletal issues in relation to that posturing because you've done that for years. There was a case like that where somebody started having issues. I think with their wrist. I think it was the secretary, a typist for decades, and started having, arthritis, issues of joint and stuff like that. That brought up. So things like that, yes, you can establish a direct relationship. But when it comes to chronic non-communicable diseases, issues like hypertension, it will be difficult to establish that. I'm not saying that, if you go to court, that probably may not succeed, but it may look like too far of a stretch. Yeah. But of course, there are other chronic disease conditions that may be related to your work. So if you work in an industry, let's say a petrochemical or chemical industry, you keep getting exposed to certain chemicals, okay, that can be linked to probably developing maybe a leukemia down the line. Obviously, that one can be established. So those ones is a chronic disease condition, and that can be linked to your exposure to your work. I had a case. Unfortunately, it became a bit murky. There was a gentleman who was working with an OMC, this petroleum industry, petrol company, and he was saying that at the filling station, whenever they kind of come and discharge fuel, he started having reactions. And this guy was a manager of that station, and apparently it is something that had just started. And then the difficulty was, fine, if this is the situation, how come it's now showing up? And for all intents and purposes, it looked like the person was developing what would look like more like a hypersensitivity reaction to the chemicals that were coming up. He started, trying to move away mostly, but he couldn't stand it. It started, affecting his work. Eventually, there was an acrimonious kind of departure from his work between him and his employers. It wasn't an easy thing at all. So in situations like that is possible. That can establish that exposure and the effect of the disease that you may have down the line. Will attend the funeral of a colleague as part of work welfare activity be considered sanctioned by the institution? Well, that's a very interesting one. That's a very interesting one. Yes, so as part of welfare, I believe that institutions have their own HR policies. And as part of the human resource policies, there are activities that are done when colleagues, become bereaved. So as part of the HR policies, if that is an activity that is done, obviously that is an institutionally sanctioned activity. And that can be in your line of duty. Yes, there's no doubt about that one. How do I correct a clinical note that has already been saved on the hospital network system? Yes, I am not an IT person, but what I know about most of our electronic systems is that whenever you log in, it leaves a time stamp, a date and time stamp. So yet, you can correct it, but it will not delete the earlier input that you made. But then if you are doing an audit, it will show when the original input was made and then when the correction was made. It sort of ties in with what we said earlier on. If you are doing paper documentation and you make an error, you don't whitewash it or you don't scribble through it. You just rule a line through it so that anybody can see the earlier error and then the correction that you made. The same thing. You cannot delete the earlier entry in an electronic system, but then when you make a correction later on, it is time and date stamped so that anybody can see the changes down in history. Please, does an MO have the right to stop or refute any surgery, whether elective or emergency? I'm trying to understand this. Does an MO have the right to stop or refute any surgery, whether elective or surgery? As in the MO being asked to do the surgery and refuse it? Yes, because so if that's an understanding, like at your station, you are being asked to do a case and you are refusing. There must be a reason why you are refusing, because you have your job description. If you're a medical officer and you are supposed to perform certain surgeries, which is within your job description, then there must be a reason why you are refusing to do your job. There must be a reason why you are refusing to do your job. If you see that a surgery is beyond, based on the indication, is beyond your skill set, then obviously it makes sense not to put yourself in that danger, because if you don't have the required skills to do that, then obviously you can indicate and document that you don't have the skills. But just refusing your duty when you have the requisite skill to do it and refusing, that will more or less amount to, relinquishing, refusing to do your job as prescribed under the contract you have with your employer, and that can have consequences. I hope I have answered that.
Yes, please, you have.
Thank you for the presentation.
We'll take a few more questions from the YouTube side of things, and there are a few questions. One, who determines whether excuse duty should be given? Is it only on request or when it is the medical officer sees the need for it? That is one of it. One question that also is coming, but there are also good commendations for the great presentation that has been done. And many have commended you for the great presentation, and also the team for the topic as well. Let me add a question that the percentage incapacity is clear in the Act, but the percentage disfigurement is not clear. The percentage disfigurement at the discretion of the medical practitioner. And then somebody's asking if you could go through the calculation of disability again. I think this particular issue, it's been mentioned that there's the workman's compensation under which you have all the details listed, and you must go through that. Of course, there sometimes, as is mentioned, the court may vary it based on circumstances and then other things that may occur, or the combinations of injuries that may lead to various what you would call disability, and then disfigurement as well. Let me add a third question that you can respond to that, please. Can a dentist issue an excuse duty to excuse the client or patient from work to be able to make an appointment? This goes both ways. So a patient needs to attend the clinic, say, in a week's time for a second appointment or something. So people issue an excuse duty for the day the person will come, since sometimes the patient says they are not sure whether they'll be released to come and see you. Is this allowed? Kindly, you can take the questions, please.
Okay, thank you. So I think I'll start with who decides to give an excuse duty. Yes, I think this is a bit it's a thorny issue, I'm sure, because we've all experienced situations where a client will come to you, you do your consultation, you come to a point from your assessment, and you think that this person is okay to go to work, but the person says I'm not fine. I think what we probably will have to bear in mind that health, as we all know, it is not only a state of physical, incapacity. There are people who may have, serious stressors, okay, that may not be obvious. Okay, so that is one aspect of it. So if dealing with such people, before we arrive on whether we can give excusability or not, we need to try and dig deeper into the psychological aspect of things to also see whether it is not something physical. Because most of the time they will just come, we do the physical examination without delving deeper into the psychological. And a typical example was a story that somebody told a few days ago. There's a big person, one of the senior vice presidents of big pharma companies, and in one of his stations, he said he employed somebody, and the person was one of their best employees. Then, after about 4 months, the person's performance just went downhill. They tried everything, put him on PIP, still couldn't make it. So they just decided to fire the person, and then it got to a point. A week before, he just called the person. Then the day before, asked the person, "No, this is not you. I've known you for the past 4 months. This is not the person I employed. So what is going on?" The other person opens and tells that my mother has had cancer. She had breast cancer, and the mother passed away. And it just took her downhill, and she wasn't a person who voices out things. So though physically he looks okay, deep down he was just breaking apart. They had to give the person time, about 2 months, to recuperate. Go through the bereavement process. And when the funeral was over and everything, he bounced back. And by the time he was leaving that company, that person was their top performer. So sometimes it goes beyond that. And I'm saying that because most of the time we assess physically and don't go deeper. So based on your assessment, if everything seems okay, and we also don't lose sight of the fact that there are people who try to use that route as a way of avoiding work. So it's more of a balancing act. It's more of a balancing act. It is not the patient that determines whether an excuse duty is supposed to be issued, but then the patient also has a say, and that say will come through if you do a detailed assessment of the patient, not only physically, but also assessing, mental state and psychological, to be sure whether you are dealing with something that is not only physical, but maybe psychological. It can be just, what do you call it? A chronic stress from the person's work, blah, blah, blah. When you go into details, you may probably understand why that probably should issue or not. I don't know if that answers the question.
Yeah.
And then
So
the
let's pick.
other one was.
We'll pick please. Have you responded to the second question as well?
Please remind me again. Then the questions are quite a lot here now.
Well, somebody wanted that you should repeat the calculation, but I think we don't.
Yeah, the calculations, yes. They are on the.
Yes.
I think for that one, if you want to do really detail, you probably may have to be a presentation on workman compensation.
Yeah.
On its own, because it's quite a detailed topic, I must say.
All right. So let's take a few questions that keep repeating as well.
Yes, I think there was a question about, let me take this one, whether you can give an excuse duty ahead of time for somebody who needs
ahead of time, yes.
Yes. So this is what happens. One of the facilities I work with, okay, has an excuse duty. And I think it was a very ingenious design. They indicate the excuse duty for the period that you are seeing the person, and then they will tell that the person needs to be seen in a certain duration or a certain date. You get it? So whilst you are going for maybe your first appointment today, when you are given the excuse duty, okay, the date for your appointment is put on so that you don't have to worry. As it goes to your HR or your administrator, they know that you have a future appointment. So that can be explored. I don't know if that answers the question. But if you issue an excuse ahead of time, what if the person doesn't show up? What will you do? Did you get me?
That makes it quite tricky.
Yeah. So you can actually indicate a future appointment on the excuse duty that you are issuing. So that takes care of it. So when the person comes back, then you issue it to cover the next appointment.
Thank you so much for taking that question. There are a few other ones. We'll try to round up very soon, so we don't spend too much time online. About the duration of excuse duties, how are they determined? Is it by discretion of the doctor attending or institutional policies? We know some of the larger institutions have their own policies and determine, for example, how many days a medical officer can give, a specialist can give, a consultant can give, and then who can sign what. But then in the smaller institutions, there's no clarity. Can you elucidate on this? And then the other issue about privacy vis-a-vis what is written as diagnosis on the excuse duty form. So, for example, the person actually has been diagnosed with HIV, and then he doesn't want the employer to know. How do you capture this so that his private confidentiality is preserved, as well as the employer also gets to know what needs to be known?
All right, thank you. So let me start with how excuse duty is determined, the number of days is determined. I mean, as practitioners, it's mostly at a, should I say, left to the determination by the practitioner, because you know you're a professional. That's why you are licensed and you've gone through training. So the state sort of trust you, let me use that word, that you're going to do a professional job, okay, by looking at a person's condition and probably having a fair idea based on science that the person may need this number of days probably to recuperate. Okay, so that is, I mean, essentially how it is done. Now, on the institutional level, those things, the classifications have been put in place just as a way of an administrative measure to prevent, should I say, an abuse. Okay, because the understanding is that when you are, let's say, a house officer, you're a medical officer, you may not know so much about certain disease conditions that are handled at specialist level that may need a certain, input of, I mean, depending on your knowledge at that level. And so if that is not controlled, you may see people, let's say, a house officer issuing an excuse duty of maybe 2 weeks for somebody who probably may have a condition that is not warranted. You get it? So that is more of like a check and balance. That is institutional level. And what that does is that it helps to, protect the institution, okay, from certain risk. So it's more like a risk mitigating measure for those health institutions. I hope that is clear. I hope that is clear with that.
Sure.
Then there's a question here that talks about issue of making the employer, is employer not entitled to know what is wrong with his or her employee? They pay monthly. Isn't it only fair for them to know that the employee has visual impairment so that they can reassign to another section of the setup? For instance, they can move a driver to an office so that they are not at risk of other roles there because they can see. Yes. So, I mean, I perfectly understand where the argument is, your question is coming from. That is a very good question. All right. But what you need to understand is that the fact that an employer will want to have certain knowledge about employees, okay, it doesn't take away the fact that the law also protects, okay, you and I, who can also be patients, okay, from our medical records being thrown about anyhow without our consent. So if it's, for example, if it's at an issue of a driver, let's say in a company, most of the time, those who have done occupational health and safety will tell you that such people are made to do eye tests, I mean, on a regular basis and all that, okay? And for example, if you're a driver, when you are renewing your license, okay, and you can't see well, what will happen? There's a state institution that is mandated to check that. I don't know if you get me, all right? The example I cited in the
Sure.
presentation, the example I cited in the presentation was this: the person may not have a permanent eye condition. All right, the person is being asked to come for, let's say, a test because of probably an eye condition that person is suffering. It may be something temporary. If you issue the excuse duty, you're not careful, you go and write certain diagnosis on the excuse duty. Mind you, the excuse is going to go through the hands of individuals who don't have any medical background. And there have been instances where people have been dismissed arbitrarily based on things like that. Because for them, they are taking a business decision, okay, based on that writing on that excuse duty that you gave, without thinking about what could be the consequences when it goes through the hands of non-medical people. It's a different thing if you are communicating with a medical person. So that is the point I was trying to put across. That be mindful. When you do a medical annual report, like we said earlier on, like the pre-employment report that is brought, there will be a portion where you have to consent, okay, that should be released, that information should be released. So if it's an eye test that you came to do in relation to your ability to drive, that will be made known. But not where somebody has an eye condition, is going for treatment, he coming today as a visual field test, and then I just need an excuse duty because maybe my eye was dilated and I need to be at home, and then you go and write at risk of blindness on my excuse duty form, and then they pass through the hands of non-medical people, and then rumors go around. By the next time I see, I've been given 1 month to go home, and I don't even know why. So that is what I was referring to, the balancing and making sure that you don't imperil people's livelihood by virtue of putting out information that is not necessary. I hope that answered the question.
Sure, I am sure some of these engagements, they are not one fine answer or so,
Exactly.
and I'm sure it will be based on case-by-case determination of what is relevant. I know there are people whose employers also sign contracts with them that they must know, and so this can become. Let's pick a few more questions so that we can round up. I think what is also key is that from your presentation, if I got something to, is the fact that we need to document when we even give the excuse duties out. I don't think that's a common practice you note. And
that's
some
very true.
develop duplicate forms or triplicate forms.
Exactly. That's a very good point.
And sometimes you give a person 2 working days, they add 1 to it to make it 12 to do whatever they do. And so it's also advised that you even write it out in words and the figure so that it is clear and people don't play around with it as well. A few questions here. We've talked about caretaker issues, so I will skip some of those questions. There was a question regarding if the person has suffered disability and after a long period, the person regains that function back. How do you handle that? And then also, for example, some of the things stated in the workman's compensation, for example, are mainly physical in nature. And so loss of a tooth, loss of a limb, etc. But the question is, for a teacher, or let's say a soprano singer or a newscaster who suffers aphasia and cannot speak again because of some trauma to the head sustained by ABC, how then do we quantify such situations? That's one of the questions somebody asked. And let me just add the last question to make it the usual 3 that we take. Somebody wants to know, is there legislation which allows patients to self-certify sickness to their employers before getting excuse duty? Yeah.
Okay.
Please, if you can take the question.
I think For the one you mentioned earlier on, I think that is one thing about laws. Laws are not static. I mean, they evolve. Okay, and that may be some of the downsides of laws, and that's why laws go through regular reviews and repeals, and new laws are, I mean, brought up. So that probably may be a deficiency in that act, because you are looking at essentially things that are outside. If you look at what has been listed, they talk about deformity of things that are outside and all that, like we were saying. So probably, like I said, that would be a deficiency. I'm sure that some of these laws may go through, I mean, reviews with time, looking at the changes in the time, so that some of these things will really be considered. And I think the problem also with things like that have to do with being able to quantify, because mostly in putting a figure to some of these things, you look at their use, okay, in daily activities. Okay, you look at their use in daily activities, and able to probably earn a living. And if you look at when the law was passed, you are looking at the 1980s. I mean, that's like almost 40 years or so ago. A lot of things have changed. How people probably even earn their living now, I mean, have changed. So I'm sure over time, some of these things will be considered when amendments are being made. But I'm sure, like I said, the focus probably was on being able to use your body parts to go through your normal daily routines and daily activities. So those are some of the deficiencies that you may see, I mean, in laws like this, but they will evolve with time. Then the next question was, do you have to certify to your employer before going for an excuse duty? I don't really know what that means, but if the questioner is trying to say that, do you have to inform your employer before going for an excuse duty? I mean, of course, that makes sense, that if you're working for an entity or an institution and you are unwell, you have to let them know that you're not feeling well before you go to the hospital. You cannot just not say anything. Nobody hears anything from you for 4 days, and then you show up with an excuse duty. Yes, that can happen under certain situations, in emergency situation where you probably found yourself in a situation where there was almost impossible to communicate. That is there. There'll be situations like that. So sometimes when you look at the HR policies of certain institutions, they will indicate that if you absent yourself from work for a certain number of days without you being heard of, you may be considered as having, terminated, unless, at the time when you show up, you're able to prove that there was no way under the circumstance that you could have communicated with them that you were not able to go to work and you come to work. You get it? So if there is a way that, you could have told them that you're not feeling well, but you just decide to stay in your house for 4 or 5 days and only show up with an excuse duty. If you're not able to prove that there was no way you could have communicated, that will raise queries. Okay.
All right. Thank you. I
think there's a question here I want to take. I think that's coming from Dr. Sylvia Digano. That is my own former boss, who has been a great mentor to me in my practice. Dr. Digano, thank you very much for your question. Her question is, if a client requests that the cause of death is not documented on a death certificate for stigma reasons, as in the case of HIV/AIDS, how can this be handled without any professional liability? But this is a bit dicey. This is a bit dicey, and it brings to mind a personal situation that we had of a client who had HIV, and he was a man. And the wife was not aware, and the issue of confidentiality, comes to play here. The person, up to the point of death, insisted that we should not inform the wife. You get it? So sometimes it can be a bit dicey. But then when the person is dead and gone, the issue of issuing the medical and death certification are backed by law. So, to my understanding, it is a requirement that you need to indicate, because the death certificates or the certificate of cause of death is going to be used for other things, which are all sanctioned by law. So in that situation, the cause of death need to be indicated, because mind you, if it's not indicated on the cause of death, and later on any issues come up, a legal issue comes up, that certificate will be tendered in evidence, and it will be difficult to defend yourself. It will be very difficult to defend yourself. So to me, what is the right cause of death needs to be indicated on that, because the document that you are issuing can come up later on. And if you indicated something else and the medical records show a different thing, it's going to create credibility issues. And mostly in such cases before the court, all the lawyer on the other side wants to do is to punch holes and more or less like create a doubt in your evidence before the court, before the judge. And the moment that is just established by those two documents, i.e., the difference in the death certificate and the medical records that you have, that is it. Your credibility will be dented before the court. So as much as possible, they must die. I don't know if I answered the question well. Then there's another one. Is there anything like choosing your patient? A patient who is rude to you, and you ask that the patient be attended to by another practitioner. It's quite interesting. It is quite interesting. So what I can say about this one is, I mean, as much as possible, we are trained, we are supposed to be professional. I mean, and one aspect of our being professional is being able to, do our work under certain unfriendly situations. So yes, a patient can be rude and all that, but the mere fact that the patient is being rude shouldn't be a basis for you not to do your professionally assigned duty. If there is someone who can equally attend to the patient to meet that same end, then there shouldn't be any issue. But if, let's say you are the only person at the station, you are the only doctor, and the patient comes in, let's say in labor, the person is being rude to you, and so you decide that you are not going to attend to the person, and the next person who can attend to that person is like 25 kilometers away. So what you're going to do is refer the person. If anything happens to the person on the way to that facility, you will be held responsible. I hope I've answered that question.
Yes,
Exactly.
I think so. So for the sake of time, as I mentioned from the beginning, this is a three-part series. This is the only presentation we would have today. Then the other two, as I mentioned at the start, would also be done at separate times to allow for a thorough interrogation of the matters. The registrar and then also the judge have had to attend to other equally important assignments, and it also fits quite well into what we are looking at so that we can have more time for these issues. The questions are many, and it's difficult to take every single question. They keep coming back. Some are being repeated, some are coming in different forms. But we would take out some of these questions, and these will continue over time as we discuss and we all continue to learn. And some of the questions will form the basis of other presentations that would come. So we would like to round up at this point. Maybe take a few rounding up points from you, and then I would toss it over to the chair for today, and then we can quickly wrap up. Hello, Raymond.
Hello. Please go ahead.
Yes. No, I was saying that we would like to wrap up at this point.
Okay.
So if there are certain key pointers you want to mention or any particular things you want to round up with, you can do so at this point. Of course, the discussions continue, and then we'll compile these questions, and hopefully some form the basis of other further discussions, and then we can go and do other topics that are relevant to some of the discussions as you have advised.
Okay. Thank you so much for this opportunity once again. There are a lot of questions I wish we could go into, but I mean, it looks like time will not allow it. So our key takeaways from here, as indicated earlier on, for the work that we do, documentation is an integral part of it all. If we don't document what we do, essentially, we did not do it. And when it comes to reporting, our documentation is very, very important. When it comes to medical reporting, we need to know where we stand as far as our level and expertise are concerned. We must know when things go beyond our level of expertise and bring in people who are more qualified than us, who are more trained than us, all in the interest of the clients that we serve. We should bear in mind our professional responsibilities that the country gives us licenses to practice, and also with that comes with responsibilities. We shouldn't allow our professional judgment to be clouded by affiliations, friendship. Let us do our work to the best of our abilities as professionals. Medical reporting and documentation have become very key in determination of cases in court. And don't assume that you are just working in a hospital. Your work in a hospital can be questioned in the law court. And let's bear in mind that everything that we do, we should have the future in mind. It may not be needed today, but in the future, it may become very, very relevant. And that should be our guiding principle in all that we do. Thank you very much once again. I wish all of us a very pleasant weekend.
Thank you very much, Dr. Med Raymond Papinfus Owusu Ansa. As I've mentioned, because of time, and we want to always keep our presentations and our sessions relatively manageable so that we can also attend to other important things that we are. So it's difficult to cover every single question. As we've said, we'll compile the questions and present to the facilitator. Sometimes it forms the basis of further discussions that we also do. And then also, you may also reach out directly to him and others within the space to also respond to some of the questions if you still have lingering issues. And so want to say a big thank you to you. At this juncture, I would like to have the chairperson for today, Dr. Bernard Hammond, say a few remarks, and then we can proceed to close. Dr. Hammond.
Thank you very much, Dr. Salome. It's been a very good 2.5 hours spent. I'm sure there's been a lot of lessons that have been learned, and read a comment by someone who said he has been writing medical reports, but today it's an eye-opener, and I identify with that. I'm also happy with the fact that a lot of people had problems with the Workman Compensation Act and are calling for a review. Dr. Abdallah, perhaps this is where we should join forces and push for a review, because as it stands, I really think that a lot more can be done in that sphere. For colleagues who are asking about the recordings and all that, we have the video available on YouTube. So you can just go to YouTube, search for Ghana Medical Association, like the video and subscribe. And whenever I go online, it's available for you. And as has been said already, this is the first part of a series that we are highlighting on medical ethics. Where do doctors and dentists stand? Still to come, we have the Dr. Usuansa alluded to it, the disciplinary committee of the Ghana Medical and Dental Council, about how it's a no-go area if for any practitioner. So we are going to have the registrar, Dr. Divine Bajubala, coming on within the next 2 weeks to talk to us on the discipline among doctors and dentists. And also we have the doctor and dentist in the witness box. So you can see it is a continuum. We are highlighting on all these because this also forms part of our work. And the tail part, the doctor and dentist in the witness box what the judge expects, and to be handled by the astute Justice Sir Dennis Dominic Ejay, who is Justice of the Appeal Court of Ghana and also of the African Court. So please look out for these dates, log them down, and let's educate ourselves so that as we are giving off our best to our clients, we also be protected. Thank you very much and for joining in, and over to you, Dr. Solomon.
Thank you, Chairperson, for the day. And I would also like to acknowledge all our members who made time to attend and also made it a very engaging session. And also thank you to the Chairperson of the committee, Dr. Med Kweku Apieje, and also our President, Dr. Med Frank Seribo, who is always quietly attending or giving his support to the committee to do as we are doing so far. So I think at this juncture, we would say we thank everybody and let's have a pleasant week ahead and look out for the next 2 weekends as Dr. Med Hammond has mentioned. Thank you all. Have a great evening. And the links to the various recordings, be it on Zoom or the YouTube, will also be shared. But you can go and like and follow, subscribe to our channel so that all the other videos that are available there, you can view them and also share them on your various platforms as well, by way of also assisting all of us to disseminate information to everybody who may not have been here. So thank you very much, and let's all have a beautiful evening. Bye-bye.
Thank you.